Hi, good afternoon. And so today we are going to begin with a very foundational yet a very important topic that is about family law in India. But before I proceed ahead with the session, a few things that I want to bring to your notice is that this is not an explicit session. There will be more sessions. It's just an overview of all the different laws. It's mainly aimed for students who are appearing for AIBE so they can quickly revise all the concepts. Okay, so there will be more, what do you say, micro sessions or multiple sessions. Just 1 minute, I'm just trying to share my screen. I think you'll be able to see my screen now. Okay. So the first topic that, as I said, we are going to talk about is the foundational yet the basics of family law in India. Now, family law is one of the most practical branches of law because it basically governs relationships that we have. They may be your blood relations, your adoptive, your extended family, etc. Now, unlike your corporate law or taxation law, which only applies in a certain professional context, okay, family law is one law which applies to every single individual at one or the other point in their life. It also deals with, you know, personal aspects of your life like marriage, divorce, maintenance, adoption, guardianship, and inheritance. So, as law students and as future legal professionals, it is very crucial to understand these legal provisions, but also the human and emotional dimensions that are involved. One of the reasons why the family lawyers have earned such a bad name is, or a bad reputation, is because they have lost that human connection. Okay. So, family law in India is something that governs a wide range of personal relationships. So, first, it is something that regulates a marriage. Now, whether, you know, a basic marriage between two individuals. So it is a legal union. Now, different personal laws, they define marriage very differently. For example, under Hindu law, it is traditionally considered as a sacrament. Under Muslim law, it is treated as a civil contract. And as you know, family law, it also deals with divorce, which also refers to dissolution of marriage. Now, each personal law, it lays down the grounds for divorce, such as cruelty, desertion, adultery, or mutual consent. These personal laws, they also cover maintenance, which is basically the financial support that is provided to a spouse, children, or parents who are unable to maintain themselves. And one such secular provision that we have was the earlier Section 125 of CrPC, which is something that applied irrespective of your religion. Now, the landmark judgment that you all must be aware about is Ahmad Khan versus Shabano Begum, wherein the Supreme Court had upheld the right of a divorced woman, a Muslim divorced woman, to claim maintenance under Section 125. Now, this case is something that's extremely important because it highlighted how a secular law could override the personal law just to ensure that justice was delivered. Now, family law, it also governs adoption. Particularly under Hindu law, you have a very specific act, which is Hindu Adoption and Maintenance Act. Now, adoption is something that's legally recognized only under Hindu law. Whereas in other communities, it either depends on Guardianship and Wards Act or the Juvenile Justice Act. Now, apart from all this, you have another important area, which is the guardianship, which determines on the legal authority to take care of a minor. Uh, the basic principle is that the welfare of the child is of utmost importance. So the guiding principle here is always that the welfare of the child is emphasized, as it was in the case of Gaurav Nagpal versus Sumedha Nagpal. Now, lastly, the family laws, it also deals with inheritance and succession. Inheritance and succession can happen in two ways. That is your interstate succession, where there is no will, and one is through will. So I'm sure all the law students know the difference between interstate and testament, or the inheritance which happens through will. Now, this basically determines how a property is going to be distributed after a person's death. Now, Hindu Succession Act is something that has evolved significantly, especially after the 2005 amendment, wherein it granted equal rights to the daughters, and they were also considered as equal co-passible. Now, moving further, okay, we studied about the purpose of family law, the nature of family law. Let's understand the overview of family law a little bit more. So, one of the most distinctive features of family law in India is that it is widely religion based, and that's why they are also known as personal law. That means that different communities, they are governed by different sets of law. Like Hindus are governed by the Hindu law, Muslims are governed by the Muslim personal law, Christians are covered by Christian law, Parsis are governed by Parsi law. And apart from this, what is more interesting is law also changes from state to state. When you talk about inheritance, when you talk about divorce, certain communities don't require that you go to a family court for divorce. It happens within the community itself. When you talk about inheritance in certain communities, it is the women who automatically inherit. For example, I'm a South Indian and Kerala, to be very specific, and in our case, most of the times, only in our district, it was that women inherited irrespective. That is, even before your 2005 law came in, property was always equally distributed between the two children, whether it is two girls, whether it's a boy or a girl. So, however it is. Now, this is basically, this pluralistic system has its roots in history, particularly if you talk about the British rule, where the colonial administration, they chose to respect religious customs in personal matters. Now, because of this, there has also been a lot of inconsistency. Anyone who is aware about personal laws knows that the marriage laws, divorce laws, inheritance, adoption, everything is different for all the communities. One classic example, if I had to give you, was Sarla Mudgal versus Union of India, where the Supreme Court had dealt with the conversion for the purpose of second marriage, and it also highlighted the importance for the need of a uniform civil code. If you have been reading the news recently, you must be aware that UCC is something that Gujarat has very recently, implemented in their state. I think it was around 23rd March or something. I just forgot, there has been too much talk. So just go through it on how Gujarat has implemented it in our state. It's a classic case study. Before Gujarat, I guess Goa was the first one to adopt uniform civil code. So now this case, Sarla Mudgal versus Union of India, is something that is always quoted when you talk about UCC in India. Why exactly do you need family law? Now, let's dive deep and understand the purpose. The objective is to regulate familial relationships. Now, law, it provides a structured framework for relationships so that there is clarity in the rights and obligation. Secondly, the family law, it aims to protect the rights of the vulnerable individuals. For example, women and children in many cases. like, you have your maintenance law, which provisions which ensure that financially dependent spouse is not left destitute. It also seeks to ensure that there is social justice and there is gender equality. Okay, over the time now, courts have interpreted family law provisions in a very progressive manner. Uh, as I said, Shaira Banu versus Union of India was a classic case where the Supreme Court had declared that triple talaq was okay, it was I'm sorry, it was Shaira Banu versus Union of India, wherein triple talaq was held unconstitutional. The family law, it also provides a dispute resolution mechanism, and family court is more trained to handle the disputes in a very sensitive and less adversarial matter. For example, you can't turn out to be very shrewd. You have to be sensitive. You have to be empathetic when you are dealing with a family court matter. You may have a lot of personal prejudice with respect to certain genders, with respect to certain members of the community, but you cannot let your prejudice affect, your client getting justice. So as lawyers, you will be dealing with divorce petition, maintenance application, custody disputes. You may have to advise a lot of people on property and succession. So for this particular, if you wish to have a career in family law, one skill set that you definitely need to develop is client counseling. Now, unlike your corporate clients, okay, family law clients are someone who are very emotionally distressed. So your role here is not only legal, but you also need to be more empathetic. You also need to step into the shoes of a counselor, but with boundaries. Okay. So, like, in a maintenance case, now the lawyer should not only understand the law, but he should also understand how many people are there in the family, who is the person who's earning. If the wife has a job, can she manage her career and the child? If the husband is the only earning member, will it be feasible for him to give maintenance to the wife? If you must have seen very ridiculous post that women are demanding hundreds of crores in alimony and all. Why does it happen? Because lawyers are misleading them. They are influenced by what they read in news articles. It is not always true. You have to understand the people who are giving hundreds of people who are giving hundreds of crores as an alimony, they can afford to do it because their net worth is that much. Unlike an ordinary person who earns 5,000, or 10,000. So there are quite a few aspects that you need to consider while you become a family lawyer. If you have any queries, you can just drop them in the comment section. Now let's move further on what exactly or how exactly are these family laws, family court laws applicable in India. So let's talk about the first phase, that is your marriage. Okay. So when you talk about marriage, you have your personal laws, that is your Hindu marriage, Christian marriage, Muslim personal law, Parsi Marriage and Divorce Act, Hindu marriage, and you have all these laws. Okay. However, there is also a very secular law which is applicable for all religions, which is your Special Marriage Act 1954, which allows two individuals to marry irrespective of religion. So you must have seen a lot of celebrities, who are from two different religions, or usually people who opt for second marriage, they go for registered marriage under this same act of Special Marriage Act. A very important case law in this context is Lata Singh versus State of Uttar Pradesh, wherein the Supreme Court had upheld the rights of individuals to marry a person of their choice, including intercaste marriages. Now, this case, it reinforced the constitutional protection of personal liberty under Article 21. Now, if you talk about a very practical viewpoint as a lawyer, you need to always identify the religions of the party, and whether the marriage is solemnized under the personal law or registered under Special Marriage Act. For example, an interfaith couple may deliberately choose Special Marriage Act in order to avoid any, conversion related complication. So let's move on to the next topic of, uh, divorce. So this area is almost governed by personal laws, and each personal law, it provides very specific grounds for divorce. For example, under the Hindu law, we have very specifically mentioned cruelty, desertion, adultery, mutual consent. There are more options. It's just for the sake of brevity that I'm explaining here. Under Muslim law, you have talaq, khula, judicial divorce. Under Christian law, you have adultery, cruelty, desertion. Parsi law has fault-based grounds. Now, in this case, practically, lawyers need to be very careful while drafting divorce petitions. How they have to be careful? They need to clearly establish the grounds. They need to provide evidence such as messages, medical records, or witness statement. While advising clients on mutual consent divorce, you need to make the procedure more faster and less adversarial remedy. What happens is most of the times it's the lawyers, because of their lack of knowledge of law, or because they just don't want to settle the case, they end up dragging the matter. You also have maintenance, which is a part of family law. It is a very litigated, it is one of the most litigated topic. And now, as per our Indian society, it is the men who are the provider and the women are the caretakers. Okay. Now, maintenance is something that is governed by both your personal laws and the secular provisions. It is very important because it is applicable irrespective of religion. Okay. So lawyers, they need to assess income, lifestyle, dependency. There should be proper documentation such as salary slips, bank accounts, and legal, papers. You need to have interim maintenance applications, which are usually filed in custody application or in your divorce petitions. Now, let's talk about adoption. Okay. So when I talk about adoption is governed differently, again, based on the religion. Now, under Hindu law, adoption is usually regulated under the Hindu Maintenance Adoption and Maintenance Act 1956. However, under Muslim, Christians, and Parsis, they don't have a codified adoption law, but they typically rely on Juvenile Justice Act, or you have your Guardianship Act. A key case in this area is Shabnam Hashmi versus Union of India, wherein the Supreme Court had held that any person, irrespective of their religion, can, irrespective of their religion, can adopt a child under the Juvenile Justice Act. So practically what matters is that any lawyer who's involved in the process of adoption should ensure proper compliance with CARA guidelines. They should assist in documentation and court procedures. You need to check the eligibility criteria of the adoptive parents. Now, let's talk about the most important aspect, that is inheritance, which is usually again governed by all the personal laws. You have Hindu Succession Act, Muslim Personal Law, which is the Sharia principles. You have Indian Succession Act, which is applicable for Christians and Parsis. If I were to talk about a landmark judgment here, it would be Vineet Sharma versus Rakesh Sharma, wherein the Supreme Court clarified that daughters also have equal co-partnership rights in the ancestral property under the Hindu law, irrespective of whether the father was alive at the time of amendment. While drafting any inheritance related documents, the lawyers need to do a basic research, whether it is ancestral or self-acquired. While drafting will, and succession plan, succession documents, Planning is the key role of a lawyer. Okay, you need to do your planning and you need to be an advisor, not play the role of a family member. In litigation, issues often arise around partition and who owns the property. Now, the applicability of family law, again, it depends on combination of personal law and secular statutes. While the marriages and divorce are largely governed by personal law, areas like maintenance, adoption, inheritance are increasingly incorporating under the secular principles just to ensure that there is justice and uniformity. So, as a lawyer, your role is to identify the correct legal framework and apply the law sensitive. You need to balance the provisions with human realities, because family law is something which is not only about rules, it is also about resolving a real life conflict with empathy and precision. So let's move further on Hindu law, or about Hindu Marriage Act. What are the rules? What is the law that applies for the Hindus? I just came a bit down. Just give me a couple of seconds. Yeah. So let's talk about Hindu law, which is one of the most codified and structured personal law system in India. Now, Hindu law plays a very significant role in governing family relationships such as marriage, succession, adoption, and maintenance. Uh, as lawyers and future practitioners, understanding Hindu law is something that's very essential, because a large portion of family law litigation arises under this particular law. Now, let's begin by understanding to whom does this law apply. It does not. It is not limited only to Hindus. It also applies to Buddhists, Jains, and Sikh, unless it is proven that they are governed by any other custom or usage. Now, how can I say it so confidently? Because this is stated under Section 2 of the Hindu Marriage Act, and there are similar provisions in other Hindu law statutes also. Now, from a practical point of view, as a lawyer, the first step in any family law matter is to determine the applicability of law. For example, if both parties are Hindu, then the Hindu Marriage Act will govern their marriage and divorce. Now, Hindu law has been codified through several important legislations which has been enacted in 1950s. First is the Hindu Marriage Act, which governs the marriage, divorce, restitution of conjugal rights, and judicial separation. The second act that you have is the Hindu Succession Act, which basically deals with your inheritance. Which basically deals with your inheritance. Then you have your Adoption and Maintenance Act, which governs the adoption and maintenance obligation. These laws, they were enacted as a part of Hindu code bills, which aimed to modernize and reform the traditional Hindu law. Now, a very important case law again here is the Sarla case law, wherein the Supreme Court had addressed the issue of bigamy and conversion. The court had held that the Hindu husband, he cannot convert into Islam slowly to solemnize his second marriage, as it would, defeat the provisions of monogamy under the Hindu law. I'm sure everybody knows a very famous celebrity case wherein the gentleman, he had converted into another religion to get married. A very veteran actor who very recently passed away. So if you know the answer, do mention it in the comment section. Who is the actor that I'm talking? So what are the key features of Hindu law? One, or the first prime feature, is monogamy. Under Section 5 of the Hindu Marriage Act, it is mentioned a valid marriage. It requires that neither party has a spouse living at the time of marriage. Now, if a person marries again during the subsistence of a valid marriage, it amounts to bigamy, which is punishable in India. A very relevant case is Bhaurao Shankar Lokhande versus State of Maharashtra, where the court had clarified that the essential ceremonies required for a valid Hindu marriage and held that mere cohabitation without proper ceremonies, it does not constitute a valid marriage. The laws and the case laws that I'm giving you reference are live-in relationship era. It also recognizes, now Hindu law is a law which also recognizes legal adoption. Under the Adoption and Maintenance Act, a Hindu can adopt a child, and the adopted child will be treated as a natural born child of the adoptive parents. In the case law of Lakshmi Kant Pandey versus Union of India, the Supreme Court has laid down the guidelines to regulate adoption, especially the inter-country adoption and exploitation of children. Why is it necessary? I don't need to mention. You have the entire Epstein files explaining why you need proper and very strong adoption laws in any country. From the practical perspective, the lawyers need to check that the adoptive parents are legally eligible. There is proper consent that is given. There is proper documentation. Court procedures are followed, etc. Now let's talk about the codified and uniform structure. Hindu law is one of the laws which is largely codified and has been in existence since thousands of years. We have the uncodified law, Mitakshara School of Law and Dayabhaga School of Law, which means it is and Hindu law is something that is more predictable and easier to interpret compared to the uncodified systems. However, the courts also do play a crucial role, in interpreting the law. Now, Hindu law is most commonly applied in areas of litigation. To conclude about Hindu law, it represents a balance between tradition and modern legal reforms. It is codified, structured, and it is continuously evolving through judicial interpretation. As future legal professionals, it is your role, is not only to apply the law, but also to understand its social context and impact. Hindu law is not something which is only about statutes. It also ensures fairness, equality, and justice, for the parties that are involved. Let's move further to the Muslim law. Now, when I talk about Muslim law, it is also codified but partially. So, Muslim law is very distinct from other personal laws because it is largely uncodified and derived from religious text. Now, understanding Muslim law requires not only knowledge of statutes, but also an appreciation of the theological foundations and the judicial interpretations. So let's begin with the sources of Muslim law. Muslim law primarily has four sources, which is your Quran, the holy book of Islam and the primary source of law. Second is the Hidayat, which consists of sayings and practices of Prophet Muhammad. The Ijma, which refers to Islamic scholars on legal issues. Fourthly is the Qiyas, which involves analogically reasoning to apply established principles to new situations. Now, these sources are collectively form the foundation of Muslim personal law. From practical perspective, unlike codified statutes, lawyers often rely on judicial precedents and authoritative text to interpret these principles in court. So, let's talk about the first aspect, which is the Muslim personal law or the Shariat Application Act. It mandates that all matters such as marriage, divorce, inheritance, family relations, the rule of decision shall be the Muslim Personal Code. Then you have the Dissolution of Muslim Marriages Act, which provides that Muslim women with statutory grounds to seek divorce. The landmark judgment that we have is Daniel Latifi versus Union of India, wherein the Supreme Court interpreted the Muslim women protection of rights on Divorce Act 1986, held that husband is liable to make a reasonable and fair provision for the future of his divorced wife, not just during that period. Okay. This case is extremely important because it harmonizes personal law with constitutional uh, principles. Now, let's talk about how marriage is a contract, civil contract under the Muslim law. Uh, what it basically means that there is an offer, that is ijab, there is acceptance, that is qabul, there is consideration, which is known as meher. Now, meher is a mandatory payment which is made by the husband to the wife, which can be prompted or deferred. Now, a relevant case here is Abdul Qadir versus Salima, wherein the court had recognized that Muslim marriage is essentially a civil contract. Now, lawyers need to ensure, to prove that if lawyers are involved in the marriage, they need to ensure that the nikah nama is drafted properly. The terms such as meher are clearly specified. The conditions agreed with the parties are legally valid. Now, moving further to formal adoption. Muslim law does not recognize formal adoption in the same way as Hindu law. Instead, it has a very similar concept to guardianship. It is often known as kafla, where a child may be taken care of, but it does not automatically acquire inheritance right. However, under secular law, the individuals, they can adopt under the Juvenile Justice Act. Again, if I had to give you a reference, it is Shabnam Hashmi versus Union of India, where the Supreme Court had held that any person, irrespective of their religion, they can adopt a child. Okay, so this was in short with respect to the Muslim law. Now, when you are advising a client, especially a Muslim client to whom these laws are applicable, you need to understand the difference between guardianship and adoption. Those are two very different concepts. You need to know the legal consequence for inheritance. Are there any options under secular law? All these are details that you need to check before advising anybody on adoption and inheritance. Let's talk about specific inheritance share. Now, Muslims have a highly structured system of inheritance with strict shares, fixed share. The shares of heirs are specifically defined, and generally it is a male heir who usually receives a share that is double of what a female heir is receiving. The testamentary power is also limited to 1/3 of the estate. A key case, if I were to speak, is State of Bombay versus Narasu Appamali, wherein the court discussed the nature of personal laws and their relationship with fundamental rights. If I had to talk about the practical perspective, the lawyers must be very careful while calculating the shares based on the category of heirs. Okay, drafting while her to the 1/3 limitation. Now, disputes usually arrive under Muslim cases for partition and succession matters. So let's talk about the developments. Now, Muslim law has evolved significantly through judicial interventions. One landmark case that everybody knows is holding the triple talaq unconstitutional in the case of Shaira Bano versus Union of India. From a practical standpoint, Muslim law, it requires a very nuanced approach. So as a lawyer who is dealing with a case under Muslim law, it is important that you understand the religious principle and the statutory provisions. You need to be very careful while drafting the nikah namas and divorce documents. You can advise the clients on rights related to meher, maintenance, and inheritance. Now, if you are a law student, I would rather suggest you focus more on the conceptual clarity rather than rote learning. You have to understand how the society works, You need to study the landmark judgments carefully. You need to understand the difference between the Shia and the Sunni interpretations. So, Muslim law in India is a very unique blend of while it is largely uncodified, courts have played a major crucial role in aligning it with the constitutional principles. As legal professionals, your role here is to apply these laws with very much of sensitivity, precision, and awareness of their social context. Muslim law is not only about legal rules, it is also about balancing faith, rights, and justice. So we will continue with the Christian law. Okay. I didn't have much time, so I didn't make a PPT. I just copy pasted everything on a Word document. It's far more easier to work on a Word document than a PPT. So let's talk about Christian law in India. So Christian law is a combination of religious principles and statutory provisions. So primarily it is governed by the colonial era legislations that have evolved over time through amendments and judicial interpretation. Now, understanding Christian law is very important because it reflects how traditional religious concepts have been gradually aligned with more modern values, constitutional values. So let's begin with the key legislations that are governing under the Christian law in India. The first is the Indian Christian Marriage Act 1872, which regulates the solemnization of marriages among Christians. It also lays down the procedure for valid marriage, including requirements related to notice, consent, and registration. The second is the Divorce Act, which usually governs divorce, judicial separation, and related matrimonial remedies. Initially, this act it imposed stricter conditions, especially on women. However, with time, amendments have brought greater equality and flexibility. Uh, Landmark case in this regard is Amineni EJ versus Union of India, where the court had addressed discriminatory provisions in divorce law and emphasized general equality. Now, in Christian law, marriage is considered as a sacrament. This means that marriage is not merely a legal contract, but also sacred and a lifelong union. However, modern statutory law also recognizes marriage as a legal relationship with rights and obligations. Now, from a very practical perspective, lawyers need to ensure proper compliance with procedural requirements under the Indian Christian Marriage Act. There has to be proper registration of marriage, there has to be verification of consent and age. A case that highlights the importance of consent is Anil Kumar Masi versus Union of India, where issue of validity of marriage and procedural compliance was examined. Let's talk about divorce now. Historically, divorce under Christian law is very restrictive. For example, earlier provision required a Christian wife to prove adultery along with additional grounds such as cruelty or desertion, making it very hard for women to seek divorce. However, there have been several amendments to the Divorce Act, which have liberalized these provisions, and now both spouses have equal grounds, including the option of going for mutual consent. I think it's Section 10, which amendment of Section 10 to the Divorce Act, which gives you this provision. A significant case here is of Mary Sonia Zakaria versus Union of India, which contributed to the movement towards general equality in Christian divorce laws. Now, from a practical standpoint, lawyers often advise clients to opt for mutual consent divorce, which is always faster and less adversarial. You need to draft your petitions properly. Your settlement terms have to be mentioned. Your evidence must be carefully presented in contested matters. Now, let's talk about adoption. Christian marriage, Christian law, it does not have proper codified system of adoption. Christians in India, they generally adopt under the Juvenile Justice, that is Care and Protection of Children Act, or the Guardianship Act, which is a very secular law and it is applicable to all the communities. Now, a landmark case again in this is of Shabnam Hashmi versus Union of India. Here, the client, if the lawyer, if you're advising the client, you need to ensure that your clients are following all the procedures of CARA. You need to check with the compliance of eligibility, assist in court process, and documentation. Again, when I talk about Christian law, it also involves maintenance, which is governed by the Divorce Act, and you have the succession, which is governed by the Indian Succession Act. So, a practical challenge often faced by lawyers is procedural compliance, especially in marriage registration and divorce proceeding. For example, failure to comply with notice requirements may affect the validity of marriage, or improper documentation may also delay the divorce procedure. So, client counseling is something that's very important, as family law is something that involves a lot of emotional and personal issues. Courts have also played a huge role in modernizing the Christian law. They have interpreted provisions in the light of constitutional values such as equality and dignity, ensuring that the outdated or discriminatory practices are reformed. Now, this reflects a broader trend in Indian family law where personal laws are increasingly aligned with fundamental rights. To conclude, the Christian law in India, it represents a blend of religious tradition and statutory evolution. While marriage retains a sacramental character, divorce laws have become more progressive and equitable. So, as legal professionals, it is important to understand both the legal framework and the practical challenges involved in applying these laws. Christian laws, like all personal laws, ultimately aims to balance tradition with justice. Okay. So now let's move further to the Parsi law in India, the smallest and the most sweetest community of people whom we have in India. And as you are aware, recently, according to news, they wanted to speak to Iranis. US wanted to speak to the Iranis, so they invited Boman Irani, Aruna Irani, and Smriti Irani. Okay, nothing serious. That's just a viral trend that's going on. So in this session now, we'll discuss more about the Parsi law in India, which is a very unique personal law system due to its very community-specific nature and specialized judicial structure. Now, although the Parsi community, it's something that's very small in India, its legal framework is highly organized and provides a very clear structure for marriage and divorce. Understanding the Parsi law is important, not only from your academic purpose, but also for a practical standpoint, especially for those practicing in family law in metropolitan cities like Mumbai, where there is significant amount of Parsi population. The primary legislation governing the Parsis in matrimonial matters is Parsi Marriage and Divorce Act. This act, it solemnizes marriage, it lays down the conditions of a valid marriage, grounds for divorce, and the jurisdiction of court. Now, unlike other personal laws, Parsi law is fully codified in the context of marriage and divorce, which also provides the clarity and predictability. So, a significant case law in this case is Sorabji Rustamwala versus Kharshed Banu, which is relating to validity and interpretation of matrimonial provisions. It's a very community specific law. So one of the most distinctive features of Parsi law is the existence of Parsi matrimonial courts. Now, these courts are specifically designed to deal with matrimonial disputes within the Parsi community. They not only include a presiding judge, but also delegates from the Parsi community who assist in adjudication. This is something that makes the system unique because it incorporates community participation in judicial decision making, like how we had Privy Council earlier, the easiest example I can give you. So, from a practical standpoint, lawyers appearing before these court, they have to be they must be aware about specific procedural requirement. You need to understand the role of delegates, prepare cases keeping in mind both legal and the community perspectives. Now, another important feature is the validity of Parsi marriage. It is closely linked to religious ceremony. A valid Parsi marriage requires the performance of Ashirwad ceremony by a Parsi priest. Just like, under the Hindu Marriage Act, you have certain procedures which are important. So, similarly, you have in the Parsi marriage also. If the essential ceremonies are not performed, the marriage may be considered invalid under this act. A very relevant case in this context is Perinben versus Nariman, wherein the court examined whether the proper ceremonies were conducted to establish a valid marriage. So practically, lawyers need to ensure there is proper documentation of marriage, verification of religious ceremonies was performed, and you need to also have the compliance with the registration of the documents. Let's talk about divorce under the Parsi law. There are 5 conditions. You have mental disorder, conversion, desertion, adultery, and cruelty. Now, over the times, courts have interpreted these grounds in a very much more progressive manner, similar to other personal laws. Okay. Now, from a practical standpoint, Parsi law may not generate as much as volume of litigation as other personal laws, but it is something that is highly specialized. So, as a lawyer, you must understand the procedural uniqueness of Parsi matrimonial courts. You need to be prepared to interact with the community delegates. Attention to detail in ceremonies and documentation is what matters the most. So, to conclude the Parsi law in India, it is a very well defined and community oriented legal system. Its unique features, such as specialized matrimonial courts and emphasis on religious ceremonies, distinguishes it from other personal law. So, as legal professionals, it is important, such as to approach such laws with both legal precision and cultural sensitivity. Parsi law, it also reminds us that family law in India, it's not about uniform rules. It's also about respecting diversity while ensuring that justice is served. Now, let's do a very comparative analysis of all the personal laws in India. Let's talk about comparative analysis with respect to marriage in India, marriage laws. So, we need to understand the 3 key aspects when I talk about all the 4 laws: the nature of marriage, the concept of polygamy, and the registration requirements. Now, let's talk about the nature of marriage. Under Hindu law, marriage is traditionally considered as a sacrament. Okay. Which means it is sacred and a spiritual union. However, modern legal interpretation also recognizes elements of contract, such as consent, legal enforceability. A relevant case here is Bhaurao Shankar Lokhande versus State of Maharashtra, where the Supreme Court has emphasized the proper ceremonies are very essential for Hindu marriage, reinforcing its sacramental character. Under Muslim law, marriage is clearly defined as a civil contract. It requires offer, acceptance, and consideration, such as meher. This was recognized in Abdul Qadir versus Salima, wherein the court held that a Muslim marriage is essentially contractual in nature. Under the Christian law, a marriage is something that is treated as a sacrament, reflecting its religious significance. However, statutory law, it regulates its validity. Okay. In Parsi law, marriage it can be described as a religious contract, meaning it has both contractual and ceremonial elements, with religious rites being essential for validity. Now, let's talk about polygamy. Under Hindu law, polygamy is something that is strictly prohibited. Section 5 of the Hindu Marriage Act, it mandates monogamy. So if a person contracts a second marriage during the subsistence of the first, it amounts to bigamy and is punishable under the Indian law. Under Muslim law, polygamy is something that's permitted for men, allowing up to 4 wives, subject to condition of equal treatment. However, in practice, it is relatively rare in modern India. Under Christian and Parsi law, polygamy is not allowed. Second marriages during the lifetime of the first wife is not. It's void. Now, let's talk about registration of marriages. Under Hindu law, now it is mandatory, but earlier it was optional. It is definitely recommended because many disputes they arise due to lack of documentary proof of marriage. Under Muslim law, registration is not mandatory, although a nikah nama also serves as a documentary evidence. Under Christian law, registration is mandatory and the marriage must comply with statutory procedures under the Indian Christian Marriage Act. Under Parsi law, registration is mandatory and proper documentation is essential for legal validity. Okay, now if I were to give an example of a case law, that is Seema versus Ashwani Kumar, wherein the Supreme Court directed that all marriages, irrespective of your religion, should be compulsorily registered to prevent fraud and disputes. So, to conclude, marriage in India under the personal laws is not uniform. It varies in nature, your legal requirements, consequences, and as legal professionals, your role is to identify the applicable law, understand the nuances, and apply it effectively to protect your client's right. Family law, especially in marriage, it's not about law, legal rules, it's about balancing law with social reality. Now, let's move ahead and talk about the divorce in India. Let's compare all the 4 laws and the divorce provisions. This is so we are talking about divorce right now. That's why I've highlighted it. So under the Hindu law, divorce is something that's governed by the Hindu Marriage Act. It basically provides both fault-based grounds and cruelty, desertion, adultery, and conversion, as well as mutual consent divorce under Section 13. Landmark case law of Naveen Kohli versus Neelu Kohli, where the Supreme Court recommended irretrievable breakdown of marriage as a ground of divorce, highlighting the evolving nature of matrimonial law. Under Muslim law, divorce takes multiple forms. Now, these include talaq, which is by the husband. You have khula, which is with the consent of the wife. You have judicial divorce under the Dissolution of Muslim Marriage Act. A significant constitutional development was in Shaira Banu versus Union of India, wherein the triple talaq was held unconstitutional. Under Christian law, divorce is governed by the Divorce Act 1869, and initially it was very strict, fault-based, but the amendments have also included the mutual consent divorce, making law more equitable. Under Parsi law, divorce is granted by the Parsi Marriage and Divorce Act and is primarily fault-based, including grounds such as cruelty, adultery, and desertion. Now, let's talk about mutual consent divorce. Mutual consent is wherein both the parties together go ahead and decide that we don't want to, we don't want to stay together and we want to separate. So, under mutual consent divorce, under Hindu law, mutual consent divorce is expressly recognized under Section 13B of the Hindu Marriage Act. Under Christian law, amendments have introduced small mutual consent divorce, making it more accessible to the spouse. Parsi law, mutual consent divorce is also recognized. However, in Muslim law, there is no the concept of mutual consent divorce exists in a very different form, such as khula or mubarak, but it does not follow the same statutory structure as in other laws. A very important case law to remember here is Amardeep Singh versus Harveer Kaur, wherein the Supreme Court held that the cooling off period in mutual consent divorce under Hindu law can be waived off under certain circumstances. Now let's proceed ahead with cooling off period. Under Hindu law, there was a previous mandatory 6-month cooling off period between the first and the second motion in mutual consent divorce. However, as per judicial interpretation, this period can also be waived off. Under the Christian and Parsi law, similar waiting period exists to allow reconciliation. Under Muslim law, there is no formal cooling off period in the same statutory sense. Although concepts like iddat, they serve a very different procedure. So, to conclude, divorce under Indian personal laws is very diverse and evolving. Under Hindu, Muslim, Christian, Parsi laws, they have moved forward to a very structured and relatively uniform approach. Muslim law retains the distinct forms, which is rooted still in the religious principle. However, across all the systems, there is a gradual shift towards fairness, equality, and efficiency. So, as legal professionals, your role is to navigate these differences with clarity and to provide solutions that are both legally sound and practically effective. Now, let's move ahead with the inheritance. So, when you talk about inheritance in India, under Hindu law, inheritance is governed by a codified statute, namely Hindu Succession Act. Now, this act, it provides a very structured framework for distribution of property. Under Muslim law, inheritance is governed by the Quranic principles, wherein specific shares are allotted to legal heirs, different heirs. Christian and Parsi law, inheritance is governed by the Succession Act, which provides uniform statutory framework. Let's talk about gender equality in inheritance. Under Hindu law, gender equality was significantly strengthened by the 2005 amendment to the Hindu Succession. Under Muslim law, gender equality is partial, as typically a male heir receives the double share of a female heir. Under Christian and Parsi laws, inheritance is largely gender neutral because it is governed by the Indian Succession Act. Let's talk about testamentary succession, that is your will. Next, the most important aspect is the right to make will. Hindu, Christian, and Parsi laws, a person has a broad freedom to make a will. Okay, he can dispose of his property through will. However, under the Muslim law, testamentary power is restricted to 1/3 of the estate. Just give me a minute, I'll just plug in the charger and come. So, however, under the Muslim law, testamentary is always restricted to 1/3 of the estate, unless the heirs, all the legal heirs, they consent. A relevant case in this case is Ghulam Abbas versus Haji Qayyum Ali, which discusses the principle of Muslim inheritance and testamentary limitation. Let's proceed ahead with adoption. When we talk about adoption, under the Hindu law, it is completely, what do you say? It is completely recognized. Under Hindu law, it is completely recognized under the Hindu Maintenance and Adoption and Maintenance Act. An adopted child is treated like a natural born child with full inheritance rights. However, under Muslim, Christian, and Parsi laws, there is no concept of formal adoption in personal law. However, they do follow guardianship, where the child, it automatically does not inherit, it acquire the inheritance right. Now, to address this particular gap, the Juvenile Justice Care and Protection Act of 2015, it provides a uniform framework for adoption across all religions. So let's talk about the governing law. Let's summarize everything. For Hindus, it is governed by the Hindu Adoption and Maintenance Act. Muslims is governed by Guardians and Wards Act. Christians and Parsis are also governed by Juvenile Justice Act. So this distinction is very critical when you are advising your clients on adoption versus guardianship. To conclude, inheritance and adoption under Indian personal laws, they highlight the diversity and complexity of the legal system. Now, while inheritance laws differ in terms of structure and equality, adoption laws show a clear shift towards secular uniformity through the Juvenile Justice Act. So, as a legal professional, your role is to identify the correct legal framework, provide accurate and practical advice, and to ensure compliance of both personal and statutory laws. Now, these laws are not just concepts, they directly impact property rights, family structures, social justice. Let's move further to interfaith and intercaste marriages in India, which are governed by a law called as Specific Marriage Act. So basically, where does this particular law apply? It applies to interreligious marriages, intercaste marriages, even intra-religious marriages where parties generally prefer a civil marriage. Now, this is the most important feature here is that religion becomes irrelevant. The law treats marriage as a civil contract between two individuals. The landmark judgment here is Lata Singh versus State of Uttar Pradesh, wherein the Supreme Court had upheld the right of individuals to marry outside their caste and emphasized that such marriages are legal and protected under the Constitution. Other important case law is Shafin Jahan versus Ashokan KM, also known as the Hadia case, where the court reaffirmed that it is a right to choose a life partner is also a fundamental right. Now, one of the key features of Special Marriage Act is that the registration is mandatory. The process also involves giving notice of intended marriage, publication of notice, waiting period of 30 days, opportunity for objection, solemnization, and registration. Now, this procedure also ensures transparency, but it has also raised concerns regarding privacy. Now, another important aspect of succession and legal consequences. Now, the children of people who've had the Special Marriage Act, they are governed by Indian Succession Act for inheritance purpose. This means that once a party marries under this act, they are no longer governed by their respective personal succession laws. This has very significant legal implications, especially in the matter of property disputes during the partition. Now, the Special Marriage Act, it basically serves two purposes. First, it promotes secular marriages, allowing individuals to get married based on their personal choice instead of the religious norms. Secondly, it provides legal recognition outside the personal laws, ensuring that the individuals are not forced to convert their religion for marriage. This reflects the Constitution values of liberty, equality, and secularism. In such cases, lawyers often rely on constitutional remedies, including writ petitions on protection. To conclude in general, with respect to the Special Marriage Act, it's a very progressive piece of legislation which upholds freedom of choice in marriages. It plays a crucial role in ensuring that the individuals can marry across religions and social boundaries without legal barriers. As legal professionals, it is very important to not only understand the law, but to also support the constitutional rights of the individual. Interfaith and intercaste marriages are not just legal issues, they are deeply connected to personal liberty and social change. Let's move on to the difference between another concept, which a lot of people are confused about: the concept of divorce and annulment of marriage. So, when I talk about divorce or annulment, the end result is the same. That is why both of these concepts, they result in the end of a matrimonial relationship. They are entirely different concepts in their nature, legal consequences, and ground. And understanding the difference plays a huge role over here. So let's begin with the basic meaning on what exactly is divorce, what exactly is annulment. So divorce is basically dissolution of a valid marriage. This means the marriage was legally valid at the time it was entered into, but due to certain circumstances, it is being terminated. On the other hand, annulment refers to legal declaration that the marriage was either void or voidable, meaning that in the eyes of law, it is treated that such a marriage never existed. Under Hindu Marriage Act, this distinction is clearly recognized as, Section 11, it deals with void marriages. Section 12 deals with your voidable marriage. A relevant case is Yamunabai Anantrao Adhar versus Anantrao Sivaram Adhar, where the Supreme Court held that the marriage is void. That is void, it cannot give rise to certain matrimonial rights, such as maintenance in some contexts. Now, let's talk about validity of marriage. The key difference in both these cases of divorce and annulment is validity. In case of divorce, marriage is valid and legally recognized, and therefore certain rights like maintenance, they arise during its subsistence. In the case of annulment, the marriage is considered either void, that is, it was invalid from the beginning, or voidable, or valid until annulled by the court. So, a marriage within prohibited degrees of relationship can be considered void. A marriage obtained by fraud may be voidable. For a simple difference, practical standpoint, this distinction, it affects maintenance claim, the legitimacy of children, the property rights of the spouse and the children. So that's why it is very important to understand the difference between both. Now let's understand the grounds for divorce and annulment. For divorce under Hindu Marriage Act, you have cruelty, desertion, adultery, conversion, mental disorder, mutual consent. For annulment, the grounds are very different and they are very limited. You have fraud, coercion, impotence, and lack of valid consent. From a practical perspective, the lawyers must carefully identify where the case falls, is it under divorce or annulment, and incorrect classification. If you don't classify the case properly, it will lead to dismissal of petition. Now, another important distinction is the legal effect. In case of divorce, the marriage is terminated from the date of decree, and rights and obligations existed during the marriage. In case of annulment, marriage is treated as if it never existed in the first place. However, the law also protects certain rights, especially of children. For example, Section 16 of the Hindu Marriage Act provides legitimacy to the children born from void or voidable marriage. Okay. So, if I were to quickly conclude this, divorce and annulment may appear similar, but they are fundamentally different in law. Divorce ends a valid marriage, whereas annulment declares a marriage never legally existed. As legal professionals, understanding this distinction is essential for effective legal practice and accurate application of law. Family law, it requires both legal precision and practical understanding. So we'll move on to the next topic, that is maintenance under various personal laws in India. So maintenance, it basically refers to the financial support that is provided to the spouse, children, or parents who are unable to maintain themselves. It is rooted not only in legal provisions, but also in the idea of social justice and dignity. You have personal laws and you have your CrPC, which deals with the both. Earlier we had CrPC 125. Now, concept and objective of maintenance. Now, before we go into specific law, let's understand the objective of maintenance. Unfortunately, a lot of rumors, a lot of misinterpretation is spread in the media by people who don't understand the concept of marriage, divorce, or maintenance. So please ignore any information that you read online and check the relevant statutes or check with your lawyers. Okay. So primary purpose is to prevent destitution, is to ensure financial stability, to protect the dependent family members. The Supreme Court in Chaturbhuj versus Sitabai had held that the objective of maintenance is to present vagrancy and destitution. Now, this principle is something that is applicable to all personal laws. Under the Hindu law, maintenance is governed by Hindu Adoption and Maintenance Act. Now, this act, it provides for the maintenance of wife, children, and aging parents. It also recognizes the right of wife to claim maintenance even while living separately under certain conditions. A significant case is Kirtikar Khan D. Vadodria versus State of Gujarat, where the court clarified the obligations of maintenance within family relationship. Let's talk about maintenance under Muslim law. Under Muslim law, it is governed by personal law principles and the Muslim Women Protection Rights on Divorce Act. So traditionally, maintenance was limited to that period, but judicial interpretation has expanded the scope. A landmark case law of Muhammad Ahmad Khan versus Shahbanu Begum, which had, it's a 1986 case, so Supreme Court had granted maintenance under 125 CrPC for divorced Muslim women. Then later, in Daniel Latifi versus Union of India, the court had clarified that a Muslim husband must make reasonable and fair provision for the future of his divorced wife. Under the Christian law, maintenance is governed by the Divorce Act 1869. It provides provisions for alimony and alimony pendulite, that is your interim maintenance, and permanent alimony, that is your alimony throughout. Now, courts have interpreted these provisions to ensure fairness and equality. Under Parsi law, maintenance is governed under Parsi Marriage and Divorce Act. The act that provides for interim maintenance, permanent alimony. From a practical standpoint, proceedings are conducted in Parsi matrimonial courts, and lawyers need to consider both statutory and procedural nuances for the same. Moving further, let's talk about the Uniform Civil Code, one of the most recent developments in personal law. Now, why is it important to conclude the session with Uniform Civil Code? The idea of a Uniform Civil Code is to have one common set of laws governing all the personal matters such as marriage, divorce, inheritance, and adoption of all citizens in India, irrespective of the religion. So the concept of UCC finds its place in Article 44 of the Constitution of India, which is the directive principle of state policy, which states that the state shall endeavor to secure citizens a uniform civil code throughout the territory of India. Although directive principles are not enforceable in courts, they serve as guiding principles for governance and lawmaking. So the UCC, it basically aims to achieve several important objectives. First is definitely to unify the personal laws, which are currently very fragmented based on religion. As we have seen throughout our discussion, different personal laws, they provide different rights and obligations. Secondly, UCC aims to ensure equality, provide gender equality, and in some laws, there are disparities in rights related to inheritance, divorce, and maintenance. Now, it has a very debated nature. Despite its objectives, the UCC remains a very highly debated. The UCC remains a very highly debated issue in India. On one hand, the proponents argue that it will promote equality, strengthen the national integration, it will strengthen legal process. On the other side, the critics argue that it may interfere with religious freedom, it may undermine cultural diversity, the implementation could be complex, etc. Now, this tension, it also reflects on broader constitutional balance between your right to equality and freedom of religion, Article 14 and Article 25, which are your fundamental rights. Can fundamental duty supersede a fundamental right? Let me know your thoughts on the same. So, to conclude, the Uniform Civil Code, it represents an effort to balance unity and diversity in India's legal system. While the aim of UCC is to bring uniformity and equality, its implementation requires careful consideration of social, cultural, and constitutional factors. It remains one of the most important and evolving debates in the Indian family law. One thing that would benefit you is you wouldn't have to study so many laws under the title of family law. If UCC comes into effect, you will just have to study one law. Okay, so thank you so much. Have a great evening. And if you have any queries, just let me know in the comment section. I'll try to upload it in my next video. Let me know how did you find the session, and do subscribe to the channel for more details.